Welcome to Wilmic's Risk Management Information Podcasts. I'm Tom Watson. In this podcast, we will talk about plaintiff personal injury work and some of the potential mistakes lawyers should avoid when handling those types of cases. I'm speaking with attorney Lee Atterbury of Atterbury & Kammer in Middleton. Attorney Atterbury practices almost exclusively in the area of personal injury. Lee, plaintiff personal injury work is the riskiest in terms of our malpractice claim statistics at Wilmic. It accounts for more than 25% of all our claims. The biggest complaint that we see is generally missed deadlines. Is that consistent with what you see out there, and what steps do you think lawyers should take to ensure that deadlines are met?
Sure. That is consistent with what I've seen over the years, especially blown statutes and blown deadlines for naming experts and so forth. And it's so easy to prevent this. What I utilize, and I've utilized for years, is a statute of limitations list. We list the date of the name of the client, date of the accident, and the date the statute runs. Now, most cases in Wisconsin it's 3 years, but of course we get some cases from Illinois, Indiana, so you need to know what the statute of limitation is. But you set out this list, you check it. If a statute is coming up, you red flag it, you get it done, and you don't wait till the last minute to file suit. Hopefully you've done a good investigation early on so you know all the necessary parties, but every once in a while, after you file suit and you go to serve people, you find that either you've made a mistake in a name or there's another party that should be named. So make your statute of limitation list and then don't wait till the last minute to file suit. Same goes for deadlines, especially deadlines for naming experts, which can destroy your case if you really blow that deadline. You should have a list of upcoming deadlines. I check these lists on a weekly basis, so I know if I need to start contacting doctors, for example, getting reports, getting all that done well in advance of the deadline. If it looks like you're going to have trouble with a deadline, contact opposing counsel, get an agreement or a stipulation to extend your deadline. I also keep a to-do list. There are things that may not be court-set deadlines or statutory deadlines, but things that you need to do in advance of either filing suit or a trial. And so you need to, I personally think I need a to-do list. And if you check these lists frequently, you don't have the problem of a blown deadline.
Sounds easy enough. Why is it lawyers miss this stuff sometimes?
That's a darn good question. I don't know what the answer is. I would guess that people who do a lot of personal injury have a method similar to mine. I know I've had partners who try to look at each file at least once a week or once a month. And if you look at the file, then you're alerted to these deadlines. You dictate something or you make a note and it gets done. I really don't know why people miss these deadlines.
Some of what I see out there is, and these are certainly not excuses, but more causes, I guess. This whole notion of, it fell through the cracks. I mean, we hear that from time to time in our claims. Or, lawyers that are either taking on a bigger caseload than they should, or, whatever the case may be. You've handled malpractice cases, I know. What do you hear? What do you see when you take these on?
Well, what I've seen is that the people I see who miss deadlines are people who probably don't handle a lot of personal injury cases, and so don't have a system to make sure that deadlines are met.
The dabblers, we call them. They're in an area where they probably don't have a lot of expertise.
Agreed. If you're doing personal injury, you need to have a system so that deadlines are met. And I think almost all of the cases I've handled where deadlines have been blown, it's because it's a lawyer who doesn't do a lot of personal injury and doesn't have a system set up in the office.
Okay. What other common mistakes do you see besides the deadlines? Oh boy. A long list, huh?
There are a lot of mistakes made. My pet peeve is investigation. Needs to do a complete investigation as early as possible in the case for a lot of reasons, but you need to identify what claims are out there, what insurance policies are out there, all the necessary parties, both subrogated parties and potential defendants, identify all insurance companies, identify all potential claims. You need to do that early on. You need to find the evidence and preserve it as much as possible, find witnesses, get their contact information, get statements from them. All of this stuff needs to get done early. I could give you a whole list of things that have to be done, but the important thing is you need to do a thorough investigation as soon as possible. One, so you can handle the case very well, and two, to find out any bad news out there. Your client may not be totally truthful. You need to find out what skeletons they have in the closet, and that stuff can really come around and bite you. If you don't identify all the defendants, you file suit, you may end up blowing a statute of limitations on a necessary defendant that you did not identify in your investigation. Same thing with insurance carriers. You need to find out the underlying insurance, umbrella insurance, underinsured coverage, uninsured coverage, all those kinds of things. You need to find out all the potential subrogated parties. All that needs to be done as soon as possible. So some of the mistakes I see are a failure to do that kind of thorough investigation. Another big area of mistake is client expectations, which is kind of another topic if you want to switch gears.
Yeah, absolutely. I know that's an important.
Right. Well, there are two big areas. One is the lawyer needs to be very conservative and not give the client an unrealistic expectation of the results of the case. I tell clients, look, I can't tell you what your case is worth or what your likelihood is of winning until I have all the facts. You need to know the liability facts. There could be potential contributory negligence. There could be a wrongdoer who is not insured and isn't recoverable. You need to see how the client heals. Will they have some permanent residuals? Will this affect their employability? And you need to find out if the client's had pre-existing problems of a similar nature. And that's why you should not give the client any kind of unrealistic expectation early on. The other problem with expectations is the client who comes in and wants to know early on, usually at the first meeting, well, what's my case worth? What's my case worth? What am I going to get out of this? Right. That's a red flag. That person has more going on than the injury case. You need to look at that person very closely. They may be the kind of problem you just don't want to take on.
How about those clients that, with the internet and everything else, they come in and they think they know what their case, what they can get, what their case is worth, and they just want you to do, carry out their mission. That's got to be a red flag too.
It is, and I get that more frequently. People do internet research and they say, well, this case in Indiana settled for X hundred thousands of dollars, and so that's what I should get. And I say, then take your case to Indiana. You have to explain to clients that the case is tried generally where the injury happens, and local juries aren't the same as juries in Chicago, New York, L.A., and so forth. And those kinds of huge verdicts don't happen around here. If you get a client who's just really bound and determined that that's the result that they need to have, I tell them, good luck. I hope you find someone who can get that for you.
I guess that ties in, too, with client selection. A lot of lawyers, I think, sometimes are in denial, or at least they ignore that little voice in their head saying, this is not a client I probably want, and they forge ahead, and they end up, in claims when, if I had a nickel for every time I heard our claims attorneys say that our insured said to them, I should have never taken that case, and I knew that wasn't a client I should take, and then they get stuck.
Yes, and I have a mental list of red flags that I look at early on. One, of course, is the client who wants an answer to the money question early on. That's a red flag. Also, clients who have seen a number of attorneys. That's a red flag. Okay, why? Especially if they're qualified personal injury attorneys, I'm thinking, Why are they seeing me if they've already seen 2 or 3 people who are qualified? There's something wrong. Probably the worst one, or one of the 2 worst ones, is the client who comes in a week or 2 before the statute runs. That's a big problem. You don't have time to do an adequate investigation. You're buying trouble. You may be buying a malpractice claim because you can't identify all the necessary parties. You put the case into suit, and then you find out, there's another necessary defendant, and it's just too late. I used to take some of those cases. I now will not, because it's just more trouble than it's worth. Also, late referrals, where you get a call from another attorney who perhaps doesn't do a lot of personal injury work. They have a client that they have been following for 2.5 or more years, and now the statute is coming up and they want to refer the case out. There's a potential problem for the same reasons. That attorney may not have done the proper investigation, and you may be just taking on a malpractice claim.
That's very good advice. I guess I find that it's easy to say that, but I suppose there are lawyers out there, particularly solos maybe, especially in this tough economic culture environment that we have. It's difficult to turn business away, and I understand that. And, of course, I guess you're better off turning it away, even if it means not getting that business.
It is. I know it's hard to say no, but for your own peace of mind and your insurance premiums, that's the thing to do in some of those red flag situations.
I suppose not getting the business certainly beats a malpractice claim.
It does. It does. And, I will sometimes take a case, not if it's an 11th hour case, but I will take a case and tell the client up front, I will work on this case for you, but it does not merit filing suit. If we can't settle it pre-suit, I won't take it any further. And I make that clear. And it's often because the case is not worth enough to cover the expense of filing suit.
Lee, I mentioned the tough economy. Have you seen any trends in personal injury law that have been directly related to the economy? Or put another way, I guess, has the tough economy impacted either the way clients are approaching these things, or has it impacted the way lawyers are having to handle these? Has there been an impact, do you think?
Not that I've seen, not that way anyhow. I think it's probably impacted the insurers more. And so I see a delay in processing claims, a delay in litigation. I think that's motivated by the economy and perhaps some of the losses that insurance carriers have taken.
So it's you still need to handle these things the same way, regardless of the economy.
You do. One thing we haven't covered, and it's another problem area for malpractice, and one I have seen over the years, is scope of representation. A person comes in with an injury claim. They really have a whole handful of claims. I've litigated some of these cases. A person hires a workers' comp attorney to handle a case, but the comp attorney ignores a potential third-party products liability lawsuit or a Social Security claim. And so you need to be upfront with, you need, one, to identify these claims, and two, be upfront with the client in writing as to what you will and won't handle.
It certainly is beneficial to have experience in this area, obviously. I speak at the law schools, and I meet with young lawyers who are trying to develop expertise in particular areas, and personal injury is one. How do you, what would you say to younger lawyers who, maybe aren't quite as experienced at this? We talked about the dabblers, those who end up taking a personal injury case when they don't have the expertise in it. But how does a younger lawyer, for example, get the kind of expertise? Do they use mentors? Do they, what's the best way to go?
Well, yes, get advice from an experienced personal injury lawyer. What I'd recommend is developing a co-counsel relationship with somebody who has a lot of experience in personal injury, and handle a couple of cases with them. Work out a fee arrangement, but make sure that you are involved in the lawsuit, doing some of the work, and are present at depositions, mediations, and trials. That's how you learn it.
You've been doing this how long, if I may ask?
I'm just trying to think. Since 1974.
36 years or so. Have things changed over that course of time?
Not a whole lot. I think there's been more sophistication in terms of expert testimony and information and use of technology, but the basics haven't changed, no.
Has it become more competitive among lawyers to get these kinds of cases?
Oh, absolutely. Well, all you have to do is turn on the TV. I mean, that didn't exist when I started practicing.
Right.
So yeah,
was a game changer.
That's a big change. Yeah.
Any other areas or red flags, pitfalls that we haven't mentioned that you think should be mentioned?
Not off the top of my head. I mean, I could get into details of what you need to do to warn a client and to investigate. One of the new features, given our current state of interconnectedness, is electronic evidence. I have started to have defense attorneys request information on my client's Facebook page. And so we caution our clients at the first meeting, be careful what you put on your Facebook or other such accounts. I don't have a Facebook account. I don't know what it's all about, but anybody under 35 at least has one, and so they need to be careful what they put on there. I also caution clients that if it's a big case, the insurance company may have you under surveillance, so you need to watch out for those things. Those are things that you need to warn the client about.
Those are definitely things we weren't dealing with 10 years ago or even 5 years ago.
Amen. But, and of course, when you're requesting information from the defense, you want to know, was the defendant driver talking on the cell phone? So you need to ask for their cell phone records for the day in question. And you're going to get that request of your client as well.
Electronic discovery, I guess, is probably the biggest evolution, isn't it, in this area?
It is. And for somebody like me, it's a bit of a learning process. I ask my kids for advice.
Well, they would know. Lee, thank you.
All right. My pleasure.
You've been listening to a Risk Management Information podcast. This is a service of Wisconsin Lawyers Mutual Insurance Company. For more information about our company, you can visit www.wilmic.com or you can call 1-800-373-3839.